For those of you joining us, we have some 180 plus of you. Welcome to the Upchurch Watson White and Max Mediation Group's webinar series. This month we have April Walker, and we're doing this in conjunction with the co-sponsor of many of our CLE programs, the University of Florida Levin College of Law Institute for Dispute Resolution, and the firm has participated in their compendiums and had a really good relationship for many years, so we thank them. And this topic really interested me when April first did it with a much smaller group, the design thinking applied to mediation. So she's going to take us through what that is, and really looking back at the fundamentals of the mediation and the principles that make it informal, and look at how that might be employed in solving our problems in this realm. And so April's been with us, what, about a year now?
Yes, going about a year, a couple months.
She's certified circuit civil. She does appellate, and of course in the federal court in the Middle District, and interestingly has developed this niche in elder law and shared family decision making. So that's also a very avant-garde area, as we have the aging population here in Florida. And myself, I've been mediating since 2001 and arbitrating since 2005, and with the firm now about 5 years. So really enjoying this series, and so we hope that this topic is sort of a little different from our usual run-of-the-mill break the impasse kind of thing, and we'll get into, I think, some more academic things that perhaps have practical application. And I think April has tempered my enthusiasm for this being the end-all, be-all, the new rubric for mediation, right? But we're going to explore some new tactics in here. So with that, do you want to take us through your overview of what,
Absolutely.
what you want to do today?
Absolutely. Thank you, Lawrence. And before I do that, let me thank you. You were actually one of the very first mediators I observed in action when I was a mid-level associate attorney. So the added bonus today is your involvement. As you mentioned, we did this as a live lunch and learn in person here in Orlando. And so we're excited to offer this to a larger audience by way of webinar today. And yes, today's program, we will begin with a brief refresher on mediation in Florida under the statute, as well as under some rules that govern certified and court-appointed mediators. We will then consider the concept of design thinking, its evolution briefly, and how it's presently understood. And third, we will consider how applying design thinking to mediation might change mediation in terms of how the mediation is conducted and the outcomes that flow from those changes. We'll also consider how practitioners might change how they prepare for mediation.
Oh, please.
Well, we'll add to the prep. So let's get started with Florida statutes. Under Chapter 44, mediation is, as we know, an informal and non-adversarial process. And of course, the roles are clear. Decision-making authority always rests with the parties, and the mediator, as the third-party neutral, assists in identifying issues, joint problem-solving, and exploring settlement alternatives.
Do you think, April, because of the emphasis on client control over the outcome, that perhaps psychologically some lawyers get a little freaked out? It's relinquishing what you see more in litigation as control?
Probably so. And I think we will talk about, some of the variables that drive the decisions that are made on mediation day, and also what I believe are not decisions at all, but probably practitioners operating on autopilot when it comes to arriving at mediation and their expectation for what will happen on that day.
Sure.
So moving to the rules that govern certified and court-appointed mediators, these are ethical standards that we know govern us, Lawrence, but I did want to point out that in addition to guiding mediators' performance in the provision of their service, These standards are also concerned with instilling public confidence in the mediation process. And also these rules add that mediators are also working to reduce obstacles to communication. Now, I also think it's noteworthy, again, in these ethical standards that govern us, that mediation is based on concepts of communication, the exchange, of course, that's the exchange of information, negotiation, facilitation, and problem solving that emphasize procedural flexibility. And I mentioned procedural flexibility here as opposed to the other concepts of self-determination, fairness, confidentiality, not because the others are not important, but of course today we're going to be talking about the informality and the flexibility that mediation provides.
And before we leave the rules, I might mention I'm on the executive council of the ADR section of the Florida Bar, and
Yes.
We have corresponded with the ADR Rules and Policy Committee in Tallahassee, which is governed by the Supreme Court of Florida, and they're concerned with people that are not certified mediating and having rules govern them. And so there will be just put on the horizon for those attending probably a case next year involving whether those rules apply to all court-appointed mediations regardless of the certification of the mediator. So for those of you that are conducting mediation outside of certification, definitely take a look at these rules, and we'll see how the court comes down on the application of the rules to everybody.
That's an interesting point, and I knew that was on the horizon. I'm glad you mentioned it. Thank you. And those rules, we've provided annotations at the end of the presentation, but those rules are available to everyone online at the Florida Court's website. Okay, so let's segue into design thinking and what is it? I think, as one writer has described it, it is a creative problem-solving approach that designers use to create new values that are different and create positive impact. Also described as the approach to innovation. Interestingly, you may also hear that design thinking is a methodology for creative problem solving that was developed at the Stanford Design School. I would say, based on what I've seen, it looks like the phrase may not have been used much before the 1970s, but design as a profession and research on how designers think started long before 1970 or the 1970s. So as early as the 1940s, from what I've seen, the thought processes and methods used by industrial designers in making things for mass consumption were being examined. And moving into the 70s with the invention of, for example, microprocessors, which enabled the creation of smart products, which could be programmed to respond to input in different ways, we began to see, I think, a movement in product design that shifted the focus of innovation from engineering-driven to design-driven, from product-centric to customer-centric, from marketing-focused to user experience-focused. Now, obviously, we're lawyers and we're not designers,
Right.
And we weren't working at HP. I think it was probably the early 70s when the programmable handheld calculators were first coming out. But as it relates to this idea of design thinking, I think eventually we all began to hear about it in terms of innovation in the business sector. And so we began hearing about this idea apart from product design. And for non-designers, we hear about this idea in terms of innovation, creating value and gaining an edge on the competition in the business sector. And so Tim Brown, who is the CEO and the president of a global design company called IDEO,
Right.
is widely quoted as, I think, saying something everybody thinks about when they think about design thinking outside of product design, and that is thinking like a designer can transform the way products are developed, services, processes, and even strategies are developed. So when it comes down to it, I think design thinking is simply an approach to creative problem solving.
It's interesting. When you brought this topic up in terms of the evolution of the moniker in terms of engineering and product development, I also look back at some of these early publications I had in ADR, and though they don't use design thinking, they talk about designing dispute resolution processes, and they talk about aspects of bringing concepts together from other disciplines into ADR. And there's even a quote in there by de Tocqueville talking about how most of the social problems devolve into legal problems, which then have to be solved by systems design such as course. So it seems like it's intuitive, and I'm glad that that you're working this in, because it really does lend itself.
Yeah, I think so. And I think if when you do take the time, if it's an area of interest, if you look at some of the materials on design thinking, you'll see that these creative problem solving approaches are found over the span of many years, different disciplines, different industries. At the end of the day, we're talking about the process of people coming together to solve either a problem, a perceived problem, a challenge. And as it relates to this moniker design thinking, it, I think, evolved first in this space of product design and development. But yeah, when I heard it the first time, Lawrence, I was actually in a bar committee meeting. I think it would have been June of 2018. So I probably had just started with Upchurch Watson, and one of my former law partners gave a brief CLE on applying design thinking to the process of telephonically appearing at a court hearing.
Sure.
And I was sitting in that meeting at the time, having already committed to preparing my first CLE as an Upchurch Watson mediator, and I had also gone to an advanced negotiation seminar for a week in Cambridge at Harvard. And as soon as I heard just kind of the steps of the processes that we're about to talk about, I immediately thought dispute resolution. Now, others may not, but let's see how it goes.
Let's look at the steps.
Okay. So this first graphic, I've actually chosen 3 graphics, Lawrence, because I think the first one is an obvious depiction of what would be a product design process. But I do think it's interesting that it's a 3-part process that starts with inspiration, and it starts first with understanding or empathy. By empathy, the focus is first on understanding the user of the product and the user's point of view. So when it comes to the product design, design thinking is first focusing on the user, the human being on the other side of the product, wanting to understand that person, wanting to understand their needs, their challenges, in order to gain insight, which will reveal new and unexplored ways of seeing the problem. Okay, so that first,
and that makes a lot of sense. I mean, that,
of course,
just because, you know, at a trial, you're trying to understand what the witnesses, the other side's, what testimony they're trying to evoke, what the jury is perceiving, and all of that. And so, the same in mediation, we want to understand the point of view of the, you know, I don't want to call them the adversary, but the other side,
right?
Because we're trying not in this process to be that adversarial default that you mentioned, the autopilot that you mentioned, and rather step back with that dispute resolver hat and fact finding and perception, and seeing what it can do for your own position by looking through the other's eyes.
Oh, I agree. And again, we're going to get, our next step will be to apply these steps to just our legal disputes and mediation. From the design standpoint, you're talking about no dispute. You've got people on a team, perhaps not all working on the same elements of design. So you may have a multidisciplinary approach, people coming together and first focusing on the other side or the end user, seeking to understand, observing, and learning that point of view. And I think that that's easy to understand when you're talking about everybody being on the same team. Now, the second phase, which is called ideation, is that process of generating ideas. So first, focusing on the end user understanding, and next, focusing on generating ideas to solve the perceived problem or challenge. Now, here, this is design thinking encourages a collaborative teamwork approach that leverages variant skills, personalities, and thinking styles for the purpose of achieving as many possible ideas that can be thought of. And so initially this process under design thinking employs divergent styles of thinking to explore as many possibilities, importantly deferring judgment. So I just think the brainstorming rule here, right, Lawrence?
Yeah, that's exactly what I said, the brainstorming, and you can do that in caucus or in joint session if you're lucky enough. And yeah, it seems perfectly aligned with what sometimes happens at our mediations, yes.
And then at some point, so, and a little different than I think probably what happens in mediation, because I think oftentimes, and we're getting a little bit ahead of ourselves, but I think a lot of times parties come with their lawyers to mediation with proposals as to what they're willing to offer and or how they see the dispute resolving. This is very different. Ideate under design thinking is literally coming together and let's pull out a pen and paper and just verbalize any and every way we might get this resolved. Any idea. We don't know if it's viable yet. We don't know if it's doable. It may be something that one side immediately scoffs at, but if it's an idea, put it down. That's the idea under design thinking. From there, prototyping is obviously that next step in building a representation of the ideas, or isolating potential solution streams and then testing those prototypes. And the testing process, eventually, whatever ideas survive that process, moves beyond to the next phase, which is implementation. And that's really that phase that takes a product to market, which we don't really have to talk about here. The only other thing I'll say about this graphic is you see the outer circles, Lawrence?
Right.
It shows that this process is fluid. So when you get past the ideas and you've created a prototype and you're testing it, well, you get feedback. You have to consider empathetically the feedback, and you may have to tweak it. So this isn't a linear process.
No, and it seems dependent on the subject you're mediating too, right? I mean, so applying this in a straight up numbers negotiation without an emotional component, maybe it's bracketing that you're testing.
Yeah.
You're trying to see where this thing's going. But if it's something that has a very heavily human element, and maybe it involves an apology or something formal to be written, or so you have I think these generative ideas to utilize in trying not to just focus on the bad stuff and try to promote something positive to come out of the resolution itself. And I like that they're concentric and that you can have storytelling going back to the ideation or point of view going all the way to the end. So it's neat.
Yeah, I mean it is, and I think this graphic it makes sense when you consider the process of product design. Now let's kind of think outside of product design and kind of move towards process designing.
Right.
This particular graphic was developed by the Stanford Design School, and frankly, I think when people see or read about design thinking, they probably wind up seeing this graphic more often than not. Well, yeah, and it's And again, it doesn't have that third phase, and yet it does. So it's simplified. I think everything that we saw in the first graphic is included. But here's how I would say this one goes. Still starting at empathy. Still working first to fully understand the experience of the user for whom the process is being designed, doing this through observation, interaction, and really a full immersion in that user experience. So we're still talking design here, and the empathy phase is still focused on gaining insight from the end user. The defining is the process of synthesizing the findings from the empathy work to form a user point of view. And again, ideate, as with the first graphic, exploring a wide variety of possible solutions through generating a large quantity of diverse possible solutions, prototyping, testing. So let's move forward, and I threw this in because frankly it's got the same 5 steps, but it's got the descriptions for anyone who calls the office and wants to see a copy of this PowerPoint and doesn't remember what we said.
So how would you apply this, like, in go back a slide just to see, in terms of like a employment case? You have an event in the workplace. You're trying to understand how that impacts both parties, defining from the empathy stage to get to something. Is the person going to remain in the position? Can you give me a little bit of a practical example of working through the degrees?
Yes. Yes, absolutely. Can we do it? A couple slides. You're kind of ahead of me, just a few.
Sure.
Okay, yeah, we're gonna get to maybe 3 slides up, maybe 4. We're gonna actually take these 5 steps and consider what it might look like at a mediation, and I think that's probably the perfect time to do that. So first, let's talk about what I think mediation usually looks like. And of course, let's talk about it because they're variables, but generally the day starts with a meet and greet, and that's you or me checking in on the parties, and if there's any initial discussions that need to be had, if you didn't have a phone call or there wasn't a mediation statement given to you, that's a mediator and separate parties. That's kind of the norm these days.
For those of you on the phone, we're seeing less and less of the letters and confidence to us about the history of the case, the outcome you'd like to see, and what the warts are on your own case and things like that. And it seems like we're more and more digging into the dockets ourselves and trying to figure it out, and then of course calling people in advance. Although many of you are so busy that I know you're running from fire to fire, it's hard to pay attention to the case until maybe the night before. But this idea that we go in meeting and greeting and getting rapport going before we even have a joint session is definitely a component of our daily activity. Sure.
Well, and I will say that in my experience thus far, I more often than not am still receiving mediation statements in advance. I like to receive them. I don't necessarily need all of the factual background. I find that lawyers would prefer to get on the phone and have a call about the factual landscape, and that's often enough. But when it comes down to, digging through dockets and reading through pleadings, it's better for the lawyers to let me know what they'd like me to read, right, or they can just tell me the key stuff I need to know. But remember now, even if you may have gotten a binder full of materials, but you've now got a client representative who you didn't talk to. So the meet and greet is going to happen either way, because you're also wanting to establish the rapport with the client who's now there. And so then from meet and greet, we go into joint session. And that's really when all of the mediation participants come together in one room. Lawrence, you or I, in our mediations, we start off the day, we set our ground rules, we make sure everybody understands confidentiality. And then what happens next? Typically, I've put opening statements in quotes, opening comments. Tell me what opening comments are like in your mediations, Lawrence, when you have them.
I'd say, again, it depends on the type of case. the counsel that are there. So it really does vary, and we can call them remarks. Sometimes I don't like to make it like a opening at a trial or whatever. We also have, for those of you on the line, many of our CLEs on their website. One of them deals with language. Howard Marcy's been teaching for years how to sort of temper your language in this process, and so we don't think of it as just another acceptable form of fighting. This is really a problem-solving endeavor. So opening statement is one way to call it. But yeah, I let people tell me where we've been in this case, where are we going, where do you see possible outcomes, and if it's a monetary demand, I usually hear that then, or I will meet with the party that's in that position just after the joint session to kind of where we're starting off from. And I might have an internal mediation right there with one side about where that opening number should be, given the context of the case or whatever. But yes, this is our default everyday, how people are comfortable operating. But I see ourselves as conveners and not necessarily that we are in charge of the process, dictating that process. And so if parties do come in, and I think we're going to explore that too, what happens when they don't want to do this. So, but yeah, this is the way that 90% of things go.
Now, I will tell you, in my experience, and I did put opening statements in quotations, one, because you're absolutely right. It's not trial. But in my experience, I've said statement because I do feel like lawyers come prepared to make the points they want to make at that session. I've seen thus far that lawyers, and I think I believed it when I was still litigating, that this is my opportunity to be heard directly by the client or the client representative on the other side. And so I use the word statement because I do find it's often prepared. I do find that lawyers will want to make kind of their strongest legal argument, their strongest point as to a legal position, and they also will probably want to talk about the law and or likelihood of success. So that's why I use that term, and I do find that's usually how lawyers come prepared to mediation.
Yeah, it's the only time they're going to have that unfiltered interaction really with the client, and not even in terms of the rules of deposition, or it's really the time to be frank about things. Yeah.
Well, you want to make that direct impression. I mean, I remember, and I feel I was trained by really good lawyers. I mean, I was trained by lawyers who put a lot of preparation into some mediations because they felt like this was their opportunity to give the other side a clear sense of what they could expect if this case doesn't settle today. And so you can imagine what that might look like.
Might and get your backup too. The other side.
Right. And so again, I think this is, as you agree, what we typically see in mediation. Now, my next slide says, well, what drives that scenario? And me being me, I think my first thought is, well, is anybody really consciously deciding that that's what mediation day should be, or is it autopilot, as I mentioned before? I think that oftentimes practitioners may not think, well, does that scenario work best for this case, or is it just, this is what I've always seen, this is what I've always done, this is what we're comfortable with?
Yeah, I think a lot of it has to do with just the evolution, particularly in our state, of the process, how the trainers tell the new mediators how to do stuff, and so they start off. But I think also the way that lawyers explain to their clients what to expect, and so when it does have a different look or feel, and I think we'll talk about it in a little bit, it does throw both the lawyer and the client off of this roadmap, as it were. And so, and I think it can be a challenge in some cases going a different route, but I find that, consistency in the approach for most cases works just fine, but you have to, as the neutral, do a little bit of feeling around before the case convenes to know what the best path will be, and then of course get permission from the parties and their counsel to do it a different way. So I guess we'll look at that. But yeah, I find that it is a habit and maybe a preference, as you've expressed here.
Well, and I was going to say a bit more on preference, because I have had lawyers say, well, it's my preference. And I think to myself, well, your preference, client preference, because you do have clients who prefer it. And I think lawyers are beholden to the preference of the client on it. If it's a preference of the lawyer, or if it's just habit, I think it's worth considering that a preference is simply a greater liking for one alternative over another. So what's the other alternative? I mean, I guess in this situation, the other alternative is to have an informal conversation in one room. We'll talk about that, because we all know that doesn't happen often at all in mediation, but that opportunity is available if the parties are able to be not to take the adversarial hats off and take advantage of that informality. I think the main driver is also, again, even though mediation is non-adversarial, the parties are adversaries, and it feels adversarial sitting in the same room with the party opponent. And so that's why I've included fear/avoidance, because I think the first knee-jerk reaction would be fear. That's kind of over the top, but I don't think so, because I think there could be a concern with loss of control in terms of how I respond, I being, in the practitioner seat, how I respond to opposing counsel, how my client is responding to the other side. So I think it's kind of a fear of emotions getting out of hand. I think there's fear over the information. I feel it's always comfortable to be in the room with my client rep and the mediator coming in and out, because if information slips, it's never a slip, because we can tell the mediator, hey, don't go say that. And I think there may be that fear in terms of, the information when we're all together in that joint session.
Yeah, I could see that in terms of maybe an early mediation where the parties don't quite yet know where the case is headed, and less so in a case that's weeks from trial where everybody's already deposed experts or whatever. And so I do think that can be a component, and maybe if there's been some brushes that are unpleasant, whether they be over objections at a deposition or during a hearing or something, that the avoidance certainly could be a reason not to get back together. But and then I see you have the preparation. It's sometimes what we call the proverbial dog and pony show is put on, and that may be already in the can for trial, but it may not be the best thing for that day, depending on the case, or it can be a great thing. I've had recently an engineer who, of course, agreed to be bound by confidentiality and didn't stay for the balance of the mediation, but came to the opening and presented animations, and they really informed a lot of the facts. And so there was a resolution of the case, and I was a little bit tentative about allowing it, but it turned out to be a great thing. So I've had accountants where they were also given the obligation of keeping confidential the process, and they were the best ones informed to give the financial situation of a particular party and do that in the cloak of the Chapter 44 confidentiality. So it was another neat way of doing something, and doing it traditionally, but with another actor that's not a party. So, those things can be very well prepared, or they can, if we've just been running with volume practice, the cases are basically the same, interchange the name of the plaintiff and defendant. I find it takes an hour or so to kind of get to people focusing on exactly what's going on in this case, but it doesn't require all that in a fancy opening.
Well, right. And I think too, again, when I say client concerns here, you may know the client well, and you may know that this is not a client that needs to sit in the same room long, because doing so might actually undermine any effort to settle the case. I do think, though, that you also just have the issue of we're all, lawyers are human beings. It's an adversarial process, litigation is, and coming into the room and being in the room with, managing your client, the information, and also responding to the other side requires a lot of energy. And so I do think that probably what drives, scenario one more often than not is it's just more comfortable, and it just gives everybody a better sense of probably control.
So what's the next scenario look like?
I think the next one, if we were to apply design thinking, and here's where, let's talk about the 5 steps. So, and I kind of started from my perspective of most opening remarks focus on law and legal arguments and likelihood of success. I think that with design thinking, every iteration of that process starts with empathy. And so applying design thinking means coming into the mediation, focusing first on the other side's point of view rather than yours. Now, already I know that sounds hokey, but that would be the application, because every lawyer and their client is intimately familiar with their position, their arguments, but really coming in resolved not to assume they've heard everything there is to hear from the other side, but to be prepared to listen and look for any opportunities to learn something different that may create a value trade later in the day. Who knows? Maybe you hear nothing new, but coming in poised to first empathize and understand the other side from their point of view. What do you think?
So this really, I think, about changing tack about what you do. Typically, though you may do a SWOT analysis or something of the nature of looking at the other side, you're actually coming in with those open ears that we talk about and actually do some active listening to the other side. Yeah.
Well, and Lawrence, I think that as I view this is a vital first step in actually creating that non-adversarial process. So it's allowing each side and or all sides to be heard. And it's also creating an opportunity for the other side to feel understood. But it's also just that process of shifting away from that trench or that gutter of my position and focusing first on the other side and hearing from them.
Right.
So
I sometimes say, like, would it be useful to talk about this?
Yeah.
And try to inject that without them seeming like weakening their position or something.
Absolutely. So that's the first step. I think the second step would be, remember, defining the problem or reframing the problem. So everybody's coming into mediation knowing exactly what the problem is or the issue is from their point of view. I think the redefining the problem based on what was heard in the empathy stage, I believe that's where each side or each party gets that gratification of having been heard, and we're now talking about this problem as a joint problem. So I'm not being bludgeoned by your version of the problem, but we've heard each other, and with the help of the mediator, we've reframed this as a joint problem we're now going to try to solve.
Yeah, I think framing is so important, and using, just to avoid a negative frame and have some kind of pessimism involved in it, rather than to sort of be introspective about the case and try to see all angles and all sides, as it were.
Now, I mean, it's easy to say, harder to do, right? Because the work of reframing and getting everybody to agree that we're having a conversation about that reframe problem, that could be some work for us as the mediators.
The buy-in is your challenge.
Oh, absolutely. But I think that's what phase 2 would look like. And then phase 3 would be generating ideas and possible solutions. Again, I think most people come into mediation having a sense of what they're going to offer, how this dispute might be resolved. I don't think people come to mediation prepared to generate ideas in a brainstorming session, either jointly or in their own room. I just don't think we have that mindset coming into mediation. What do you think? Have you ever seen it?
And I was looking at this scenario, and I thought of a case, and I think generally these are cases where the parties have a prior relationship. It's not necessarily a tortfeasor and somebody injured, and it's not necessarily an employee or employee thing, but maybe in a B2B or an IP case. In particular, I was thinking of a case involving a publisher of a children's set of books and the illustrator of those books, and they had a falling out, but they both had a mutual interest in getting these things to market, and it was a question of who owned the drawings and this and that. But we actually did have quite a long brainstorming sort of a rejoint session of reconvening, which ended up in an agreement, and it got so real as that we were, after the mediation, transferring cartons of books from one card to the other for these people to distribute. So it was really interesting, and it was one where I think because there had been a long relationship that wanted to be salvaged, but there was a bubbling up of some problem financially and otherwise, that it was able to have that through the brainstorming and doing it differently. And those cases are few and far between, but they do exist.
Well, and I think, it's noteworthy here that as you and I, and as the mediator is interacting between the parties when they are in caucus, we are always working on generating ideas, right? Because we're hearing from both sides. I think here, if this was a design thinking process where there's collaboration on both sides, there'd be some effort to do this together. But this happens all the time in mediation. The question is, how much of this can you incorporate in a more robust joint meeting? But I think that's the third step. The fourth step is developing proposals. So when it came to a product, you're prototyping. When it comes to a dispute, you're developing proposals. Now, if it's under design thinking, you would have a list of ideas that were generated creatively and openly, and then you're pulling from those ideas. So frankly, it's not an idea nobody's heard of, because they've already been part of the brainstorming session. And pulling from ideas generated to create proposals, and then testing those proposals by presenting them to the other side for feedback, incorporating rejection, repeat. So I think that's just the process of putting together a package that's palatable for the parties. Then that's the path to a settlement.
I'm going to keep a copy of this in my wallet. I mean, we have to force. I think
wallet. I want to see your wallet when you do it.
Shrink it down, but we have to. I think it's sometimes apply these new rubrics to what we do as a knee jerk and what parties feel comfortable doing. And so I'm just thinking about even a couple of these steps in terms of something that it's not quite going swimmingly. It might be a great thing to do occasionally.
And see, when I heard this, and I'll just say shout out to my former law partners, Jason Kerala in the Miami office of Carlton Fields did this brief CLE on design thinking. And when I see these steps, that's what I think, well, that's what mediation is, isn't it? I mean, isn't that what I'm doing when we're not in a room together, working together, and I'm going between rooms, we're testing proposals. We're in these rooms putting together packages and proposals, and we're testing them with feedback. So I think this framework called design thinking gives you, this concept gives you a framework for thinking of it in a new way, and it just interjects that collaboration element. And even though I don't think all parties show up to mediation viewing it as a collaboration or a joint creative problem-solving endeavor, at the end of the day it is, because nothing's getting done unless we all cooperate and come together and work together, even if we're in different rooms. So you've already said some things about some case by case. I remember when we talked about this, we wanted to be sure all of our attendees understood. This is by no means an effort to suggest that there's anything wrong with scenario one. And in fact, oftentimes there won't be a joint session. I just mediated a case on Monday, and I had a set of folks on one floor, and I had a set of folks on another floor, and never the two met. And
get your exercise.
I did get my exercise because I was up and down stairs. But so case by case considerations, absolutely you will not have a joint session in every mediation. And so
I mean, it's becoming, just studying the field nationally on the West Coast, this is now the norm, is not to start together, which seems counterintuitive, but I think the idea is not to set back any potential progress by having those contentious openings that really get people in their corners, and you spend a couple hours calming everybody down and then getting back to the business of the deal. So I do see it is appropriate for a very high stakes matter where, let's say, business partners have devolved into litigation, or somebody leaving medical practice, or there's definitely a context where this is like something to be thought about from the beginning. Sometimes I'll meet people in the caucus room before we start, and I'll just get a sense that, you know, this is not going to go well if we get together, and I'll give them the ground rules separately and all of that, and they don't seem to be too bent out of shape by doing it differently that way. But we do have when we do it at our place, a kitchen and cookies and all these kind of things, and people will run into each other. And it's sometimes, I find, when you have the less emotional case, but you have people from the C-suite on both sides of a business case, that maybe getting a cookie together, they're going to solve the case better than any of us can.
Yeah.
And so when it gets late and again people get tired and whatever, I sometimes try to get counsel to let go of having total control of the dialogue and let the parties actually, if they have a relationship, sort of slip back into that comfort. And I'll either babysit it or I'll put them in a room, tell them, you know, knock if you need me. And sometimes that actually breaks the ice on a difficult case. So it is, it is case by case. You have to look at all of these options.
Well, and this reminds me of an earlier slide where one of the concepts underlying mediation in Florida is facilitation. So all that simply means is to make easier or to help bring about. I mean, we are there to help make it easier. And if it's easier for the parties to have a settlement discussion by not seeing each other, not being in the room, then that's what works. Multiple party cases would also be an issue, I think, because if you were attempting to have a more robust joint meeting and you've just got a lot of folks that need to talk, I mean, we're on the clock, it's time, it's money, and so that could probably militate against spending a lot of time attempting to have a lot of conversation and joint session. But you've already said it, communicating with your mediator in advance is the rule of thumb. I have not yet had a situation where parties did not need to be in the same room and the lawyers didn't know it. So I think lawyers always know when it ain't gonna work, and they do a great job letting us know.
Yeah, and I'd say on the multi-party thing too is if you don't start off in a grandiose forum, and I've had cases like a trade secret case where somebody made off with software but they didn't know who, and there's 23 defendants, and you have to kind of do something. And then when everybody's alone in their caucus room and you've really focused on one or two parties, and you have to make sure that you get back and know that, listen, I'm working in the other room, just because I haven't seen you in 2 hours, it doesn't mean I forgot about you, this kind of thing. And I try to do that. I know as a litigator, I felt ignored sometimes in a construction case where there's a whole bunch of days going by where I didn't see the mediator. And so I make a conscious effort of trying to make the person feel like they're still a part of the process.
Oh, absolutely. And then I don't want to overlook legitimate concerns of violence, because actually this is a real issue. I mean, and let's encourage our attendees to have a real sense of if you're going to potentially have issues like this, because we don't want anybody to be in harm's way, and we don't want a mediation to turn into tragedy and or mayhem. So
I had one with a metal detector, so it's not unheard of. They wanted it done not in the courthouse, but it was actually brought to a condominium clubhouse with a magnetometer. Imagine that.
Well, yeah,
so,
better safe than sorry.
Yeah.
So those are the case-by-case considerations. I thought I just wanted to throw this in because when you talk about a robust joint session, I thought it was interesting that when I attended that seminar, that workshop at Harvard, there is a particular conflict resolution model called the understanding-based approach, and I've given you the book title, Challenging Conflict, Mediation Through Understanding. That model is actually where the parties take center stage and sit in a room together and work to create a resolution. And
I saw this and I was like, okay, I know this case. There was a case I co-mediated years ago. It was involving, when you remember those little disposable cameras, and they used to have like a pre-printed image. There were NASCAR ones of your favorite driver. There were sports teams or whatever. So there was before the digital camera really took off, and
Yeah.
they would sell these at Kmart's and whatnot. And huge patent infringement case over the mechanism of getting that image pre-exposed on the cameras. And anyway, it was a complicated patent case, but the parties that were involved started to see that the case was kind of getting a life of its own, and they wanted to get back to business of selling these damn things. So they, started basically what looked like a bazaar in this conference room where they had brought, exemplars of the infringing products, and the distributor and some of the inventors. But it was really interesting to see sort of let go of the reins and have everybody kind of come up with what makes sense on a business side to get to an agreement, to continue to do business together, but to have a more fair royalty. And it was really like, it's very interesting parties. I can't get too specific on here, but it was really a clash of cultures, of countries, of the way of doing business. But it ended up resolving wonderfully for them. And I just was almost a spectator at some point. And that's one thing I would say is don't let your mediator get in the way of the settlement. So,
well, right, right.
As much as we're trying to apply these things and make stuff work, it could be that the synergy of having everybody, like this third scenario, in the one room together actually does something. It creates a new earnestness about completing the resolution.
I love that you shared that, and I agree with that. I do think there is a temptation to think, oh yeah, in certain family type matters, maybe. But I 100% agree. There are business situations where the best thing you can do is kind of get that energy going with the parties and make sure the lawyers don't get in the way, meaning the advocates and the mediator. Okay, let's zoom because we're actually chit-chatting and we've got quite a few more slides, which is great. So I think that, first of all, so you've got all these options, and that's the beauty again of mediation. So different approach, additional outcomes. I mean, obviously settlement is the ultimate desired outcome, but if more thought is put into it, depending on your client, whether they're sophisticated or not, remember, we're still working to instill public confidence in mediation. We say it's non-adversarial. For goodness sake, everybody, please try to come in and not be adversarial. And if it means brief remarks and let's go to caucus, then let's do it, because it is informal. We're selling it as non-adversarial. Let's not feel like we're in a cage match. I think more participation and direct observation happens the longer all of the mediation participants can engage together. And I think we all become better communicators, negotiators, and better at problem solving when we're actually working with tough folks. I mean, I don't know that I get better at communicating when I'm talking with someone who's not pushing me. So I feel like there's that personal and professional development that happens when we discipline ourselves to put down the adversarial hat and work together, because again, it's conflict resolution. What do you think? I mean, for me personally, I like when people come together and can talk and work things out, even if they need me to have that conversation, but I understand it doesn't happen all the time.
No, I think, it obviously depends on the amount of participation, and I think just having that overall objective of working on it and getting through with it. Some people want to hold on to a case, and I understand there's reasons for that, and it could be a party or a lawyer even, and it could be an industry that just wants to use this going forward to teach a lesson or dissuade other litigants or whatever. So yeah, you have to look at each one, but it is better when everybody's trying to at least give their best on that day and not to obstruct.
Well, and if it's a case where one side really needs a formal adjudication, they want to set precedent, they want a formal adjudication, then then that means if the court's ordered you to mediation, I mean, I don't know, you might not be at mediation long if that's a really high interest of one of the parties. So I think here preparation is key, and I kind of listed here some things that I remember that I did when I was preparing for mediation. When you have time for mediation prep, you're going to make sure you know where your pleadings are. You're going to make sure, I think, what the key docs are, because if you're going to have an evaluative conversation about some of the key things that are driving the numbers, I think you look at key docs, and of course you prepare your mediation summary. You meet with your client. But here are some other things I think you might consider, particularly if you're looking at kind of playing around with the process. I mean, first of all, prepare your client for a joint session that goes beyond just spitting out your opening statement and/or segments of what you sent them as a mediation summary. I think gauge your client's willingness to participate in a more robust joint meeting. If they're not willing, then obviously you're not going to go that route. But like you said earlier, Lawrence, you don't want to be in a situation where someone is being asked to do something they're not wanting to do, particularly your client. I had talked about that kind of concern about information and information slipping when you're all together. I think you identify and agree very clearly on the limits of what will and won't be discussed in the same room with the other side. Similarly, what information absolutely will not be disclosed. You said that's particularly true in an earlier on in the case, and that makes sense. And then finally, discuss and identify ideas, possible resolutions. I think that happens often anyway, but again, not just what we're willing to do, but maybe just being a little bit more open about creatively. And I think lawyers and their clients do that anyway.
I do want to say that I always tell the parties not to hold off sharing information. It may not be at the outset, but I think what I try to do as a mediator is, of course, gather nuggets to share, of course, with consent and permission with the other side that drive the thinking on the case. Because as you know, the cases, depending on the type, will start out fact intensive and positional and with some of the law, and then sort of fade into the negotiation on numbers. But there are cases where disclosing something at the right time in that negotiation will drive that settlement. And I don't like this whole I'm holding it for trial stuff, because I mean, how many cases try anymore? So, yeah. I try to get them to let go of some of that, because I find it does drive a better deal.
I agree, and it is tough. And this is, and by the way, that's one of the perks of trying to work together in one room, because you are directly observing and hearing, because there are the situations where I am in one room and I get information and I absolutely cannot share it. And I may be the person, depending on the lawyers and depending on how sensitive everybody is to the information, I may walk out with way more information than you could have had if you tried to sit in the room together. So I think we had a couple questions, but we're actually at 12:57. I think we may have actually covered the 3 questions we thought we might address. But did you have anything else? Because I just had some comments before we go to that last slide. I think we've got annotations here for anybody who's interested in reviewing those rules. We've got some design thinking articles in those graphics.
Yeah, there's some neat stuff you have here, so that'll be available for those of you that want it. And I do just think, in concluding, that there's participation comes with the interest in doing something different. And so we've been looking at ways to explore building consensus in a different fashion, and I think you've given us some of those alternatives, and it's pretty neat. So let me go ahead. I know you had a couple comments, and then I'll give the course number for those online. Go ahead.
Thank you so much. I appreciate the fact that some of you sent us questions. I think we'll work on sending, answers if we didn't already cover them. I just wanted to say thank you to those of you who took the time to call and participate today. We view mediation as a really incredible opportunity for the parties and the lawyers to pause the adversarial litigation process and sit down in an informal setting and discuss how the dispute might be amicably resolved. I can say, in my short time as a full-time mediator, obviously not a short time as a lawyer, but I see, unfortunately, that the inability to take that adversarial hat off can really thwart any efforts to have a meaningful dialogue. And so I'll tell you that more often than not, I've had success with cases settling at mediation, but it's been a tug and a push, and it's not always as pleasant as I think it could be if we could all remember that we're in a confidential setting, and we can always put the gloves back on when we go back to court. But for purposes of mediation, we really are here to solve the joint problem of being kind of stuck in a dispute. And so I hope that today gave you a kind of a fresh perspective on how you can view that process, how you might prepare yourself and your client for that process. And either way, no matter how you come, we're always happy to mediate your cases for you. So thanks for choosing us when you do.
So for those of you on the line, the course number for the Florida Bar has been pre-approved for 1 hour of general credit is 1901038, N as in Nancy. That's 1901038, N as in Nancy. And for those of you that want to use this for DRC credit, just be sure to share the title and content when you renew your certifications. And with that, I believe we're going to go, April. I don't have the next date of our next webinar, but be sure to check with our website, uww-adr.com, in the upcoming events or in the CLE status. And we have a bunch that are still active through 2020 for those of you that need credit. And thank you very much for attending.
Thank you so much for attending. And Lawrence, let's do it again. I enjoyed it.
Yeah, it was a pleasure.
It is. Okay. Bye-bye.